Kashinath Jadhav, a distinguished legal scholar and an academician with an impressive background. Dr. Jadhav holds LLB and LLM degrees from the Savitri Bai Phule Pune University, specializing in corporate law, and has earned gold medals for securing the first rank in both LLB and LLM. Dr. Jadhav's journey includes practice in the Bombay High Court and a stint as a legal associate at a leading Mumbai law firm. He completed his PhD in 2020, focusing on the constitutional and judicial aspects of the death penalty and mercy petitions. As a faculty member at the National Law University, Jodhpur, and later at the National Forensic Sciences University in Gandhinagar, Dr. Jadhav has excelled in teaching criminal laws, constitutional law, administrative law, and labor laws. He is a prolific author with numerous research papers in esteemed law journals. Beyond academia, Dr. Jadhav has contributed significantly to forensic law, serving as a resource person in workshops and training programs. His international engagements include sessions in the Indian Technical and Economic Cooperation Program, sharing insights on forensic evidence, criminal laws of India, and international perspectives. Currently, Dr. Jadhav is actively engaged in cutting-edge legal research on contemporary issues in forensics and criminal law, contributing to policy studies in these crucial domains. We are privileged to have Dr. Gaurav Jadhav with us today, and we look forward to gaining insights from his rich knowledge and experience. I would now like to invite Sir to deliver his address on the paradigm shift in the criminal investigation, a forensic evidence perspective in India.
Very good afternoon to all of you. First of all, at the outset, it's my profound privilege to have amongst us Professor Gurkur ma'am and Professor Vibhuti sir. I'm extremely privileged to have their august company here because they both are my gurus and they both are considered as professors. So thank you so much, sir. Thank you so much, ma'am, for inspiring so many students like us. And we are bound to follow your footprints in legal education. So with this, I once again thank both of you. Then I heartily thanks to CMR University for inviting me here and granting me this opportunity to participate in one-day national seminar in criminal justice, forensic justice and forensic science. So I'll be directly dealing with the title of my presentation over here. I can recall that few days back when I had invitation of this seminar, I think Arzu ma'am had asked me what is your title of session, and then I was struggling with the nomenclature, what should I include, and then I come up with this nomenclature that paradigm shift in criminal investigation, a forensic evidence perspective in India. So before I actually start with this title, I feel it as a pious obligation to introduce you that I am a part of National Forensic Sciences University, which is the first and the only university dedicated to forensic field. And I am a part of School of Law, Forensic Justice and Policy Studies, wherein we learn the the law as such. Then we do certain works which facilitate the forensic justice. We have an ecosystem of various departments like media or ballistics or cyber forensics, so many things. So we do idea exchange over there and we come up with certain policies. And then we render certain suggestions and sometimes we prepare certain briefs for Ministry of Home Affairs. So this is what the institution that I belong to. Coming back to my title of this presentation, the word paradigm shift. Professor Vibhuti sir has 2 times used that word in his session. Paradigm shift. This is the word that was coined by a renowned scientist and a historian. His name is Thomas Samuel Kuhn. In 1962, he wrote a book that is Structure of Scientific Evolution. This is a very authoritative book in science and more than 10 million copies have been sold. In that book, he has used this word paradigm shift. And now that word has become quite cliche. Many times we use this word. But here I want to take some insights. Why he used that term, what was he meant, and why this particular term could be relevant in our today's seminar. So for paradigm shift, he has given 5 points. These are those 5 points. I'll read one by one. Firstly, pre-science to normal science. Because he was a scientist, he was a historian, he came up with the idea that how science deals with or combats the changes. because science is never static. There are new theories come up, and new versus old, this kind of struggle is bound to happen. So earlier there was haywire, or you can say there was scattered kind of scientific theories were there, which ultimately become a consolidated piece of science. You can take any example of Newton's corpuscular theory on light, or then so many things. Now we are defining what is the definition of light, how it is made up of, and those waves and everything. So from pre-science we have come to science, and now we have a database. So this database, what we have today with us, that is a paradigm. That word that you use, that is current database that you have with you of knowledge or theories or experiences, that is your current paradigm. Then we went further, and slowly, as and when society changes, there are currents and undercurrents are going on. And that is how, whatever is static, that is meant to be challenged. And that is how science is always giving this opportunity that you come up with your theories and challenge it and come up with your hypothesis and establish your theory. That is how we have several theories of science. So when existing database starts shifting, there we enter to new phase, that is model drift. After that, once the model or present theory started moving, then there becomes a crisis, because established values and what is coming further, they both sometimes not matching with each other. And that is how this crisis gives rise to next thing, that is evolution of altogether new theory. That is what he called as a model solution, and that is incommensurable. That means new theory does not find any relevance with absolute theories, and this struggle is quite obsolete. This struggle is quite inevitable. So when your new theory does not hold any relevance with your old theory, you have to change the theory altogether. You have to enter to a new knowledge domain where you have to shift entire database, and that is why he used the word paradigm shift. That means whatever existing parameter or paradigm that you had, now that is shifting. Now if we apply this diagram to our criminal justice system, it is quite relevant, because law is ultimately a kind of social science. So when we talk about this model, earlier we have several theories of law, how to punish, several theories. What is the purpose of law? There could be so many theories, so many schools are there. Now they are having struggle. So new theories are coming up, new models are coming up, then crisis is inevitable. And now, then after we are moving towards new technologies, because society is changing, we are bound to change. So our obsolete techniques, for example, of criminal investigation, now they have become obsolete. They are not finding that much relevance with constantly changing society. We cannot have obsolete techniques like TIP, test identification per to absolutely establish the guilt. We want to have a new techniques like DNA technology. And that is why our criminal justice system is now entering into paradigm shift. And that is why I have chosen this title, that let's analyze, because already the paradigm has shifted. We are quite late to realize it, because the crime and criminality both are changing, and we are we are having a trail kind of thing. We are trying to pursue them. They are quite ahead to us. Let's just confess this. And that is why, as a forensic justice or as a platform of forensic science, it becomes our duty to deliberate upon what could be done. How can we catch those constantly changing crime and criminality stages? Then I have picked one line, and I think that is quite relevant. In the grand theatre of justice, because many times that word is used, courtroom drama. Why that drama is there? Why that courtroom becomes so much dramatic? Many times you must have seen in so many movies. So in the grand theatre of justice, forensic evidence assumes the role of brilliant spotlight. There is a spotlight on the stage, that banishing the shadows of doubt, because when forensic enters, it is bound to handle the doubts. There are so many doubts. How the crime has happened, who committed the crime, what are the modus operandi, how he concealed the evidence, so many things. So those doubts are there, and forensic helps to remove that doubts. So that spotlight of forensic evidence banishes the doubts and exposing the actors playing their parts. Now who are those actors? Actors could be victim, actors could be perpetrators. So based on that, their innocence may be there or their guilt might be there. That is what, and ultimately the drama compels us to reach the truth. Now this journey of forensic evidence till the truth is not an easy task. It takes so many turns, so many currents, undercurrents are there. So in this session, I have picked up the method of case studies. I will be dealing with some of the cases that Indian judiciary has decided. There could be cases that are dealing with forensic evidences. There could be cases dealing with circumstantial evidences. Because being a part of fraternity of forensic science, these days we are having quite restless feeling, because if you are observing properly, the judgments are coming up, and typically the judgments are consisting with acquittals. So that makes us restless because we don't mind that people are getting acquitted. That's a good sign that one person who is now incriminated, he is now exonerated. That is fine. But what about the perpetrators then? If one person is acquitted, that gives us two things: an innocent was incriminated, and the real perpetrator is still out. So how to solve this puzzle? And the way in which, in like 5 to 6 days back, on 16th of October, Nithari judgment came by Allahabad High Court. And in that judgment, we all know that the two main accused persons, they were booked for 12 offences, 12 cases were lodged against them out of 16. So they were acquitted by Allahabad High Court. I have included some insights from that case as well. And we will access these cases from the view of forensic science as well as criminal law. And let's find out what insights we can get from that. Moving forward, now as I said, changing nature of crime, criminals and criminality. Like society is quite changing. I have borrowed some little older kind of database just to give a glimpse that how criminality is changed. And the data is from FBI, authorized website of FBI. In 2016, they have published some statistics that no doubt in USA now, the actual robberies, the number of robberies are decreased. The number of attempts that actually person goes to the bank or does these kinds of robberies, they are decreased. But the amount of robbery is now increased. Because the perpetrators, they don't need to visit physically to the crime scene or commit any robbery. They can sit on their in some chair and click certain buttons and they can commit the robberies. And the amount of that online frauds or online robberies are more than what within a 1 year actual robberies are happening. So that much magnitude of crime and criminality is changing. So what are we dealing with that? How are we going to deal with that? I have taken the same measures from USA. It is not bad to compare two things. That gives us enlightenment. So I have taken this, the next part that is from USA. Again, FBI is resourceful for that. On their website, they have mentioned about CODIS database. CODIS, Combined DNA Index System. That is what they have come up with. Now, what is CODIS? CODIS is not new age technology. It is quite old. Like in 1953, Watson and Crick model was introduced. After that, DNA science has gone further, and in early 80s they have come up with this database. And by 1997, almost 91% of US population came under CODIS database. Now, what is CODIS database? Now it's like a combined database. What is combined? There are two types of databases that they have. Firstly, a database that is called as the Convicted Offender Index. That means they are using DNA technologies for the individuals who are convicted, actually convicted. So you have a judgment of conviction, you can store their DNA samples with them, they have that database. And secondly, forensic index. Now this forensic index is what? Whatever DNA is that you collect from crime scene, a separate database is maintained for that. That means you have a database of culprits, you have a database of unknown people that you found on the crime scene. So whenever a new case comes up, they try to tally whatever database that they earlier have and whatever they have found in the crime scene, and then they match together. And that is how they are pursuing the criminals. And when they get this match, they call it as a CODIS hit. CODIS hit means now they have got a confirmed match that one person who was having an entry in the database, he has committed a crime or he can be located. So by that thing, they are enriching their databases, and that is where they are quite resourceful, or they are quite speedily they are pursuing the criminals. Now, it is a debatable topic. Should we go for that? Because Professor Vibhuti sir has extensively dealt with DNA bill. Even Gurupur ma'am has also mentioned several insights about that. So, what other countries are doing and how we are struggling with that? Because we have to clear so many doubts. Just like sir has said, privacy concerns are there, dignity concerns are there. But what about the criminality then? What about the conviction rate? And what about to leading to the justice? Can this kind of technology, this kind of databases helpful to us? Now it's a question that should be coming to our mind, and ultimately we are bound to find the answers for these questions. Then transformative nature of criminal investigation, because we are dealing with paradigm shift. What kind of transformation is going on? Section 9 of Indian Evidence Act talks about identity of the accused person. In that, test identification parade is there. Like a witness is brought before the magistrate and they conduct the test identification parade. Some identical people will be standing in front of him, and based on his memory, he will identify, yes, this person is involved in that particular thing because my memory says so. There are several do's and don'ts, like the witness should not see the photograph of that person because now the memory will fade away. These kind of things are there. Prior to that, we have anthropometry or Bertillon system. That means what we used to take bodily measures, a measure of shoulder, measure of face, nose, everything, and that is how we used to keep the databases of criminals. Now then there was systolic blood pressure test, like if you tell lie, your blood pressure might be manipulated. So one machine used to be there, they used to attach that machine to the body, and they used to measure everything. These are quite old techniques. Now we are moving towards some sophisticated modern techniques like DNA testing is there, then we have polygraph. Now whatever that systolical blood pressure test, now we have polygraph, an advanced version of that. Then we have brain electrical oscillation signature, BEOS. This is one of the modern and sophisticated techniques. And the credit for this BEOS goes to one of the person who is from Bangalore, I think, Mr. Mukundan. He is from the NIMHANS, who was instrumental to prepare this model of BEOS. That of course it's a non-invasive technique. That means human body is not required to be manipulated. Whatever electrodes or things that are externally attached to the body, that is non-invasive technique. Or narcoanalysis, you inject certain chemicals to the human body, that is invasive technique. You manipulate with the thought process, you actually affect the body, and under the influence of that particular chemical, the person is trying to speak and he gives certain things that is there in subconscious mind. When we will be dealing with etheric case, we will be having excess of that. Then several methods of forensic science are available these days. So that is how our criminal investigation is now becoming forensic investigation. Just like rightfully quoted by our Honorable Home Minister Mr. Amit Shahji, that henceforth, upcoming, whosoever those offences for which punishment is more than 6 years, the forensic investigation would be mandatory. So that is what they are trying to do the changes in the law, and of course very soon this kind of provisions you will find that how forensic investigation to be conducted, how it is mandatory to be conducted, who are the people who will be responsible for that. There could be so many questions around it, but yes, the upcoming time, within upcoming time, we will definitely have the answers for this. Then, quality of investigation from traditional means to the forensic means. Now, as stated here, what is the outcome of investigation? For why we conduct investigation? There could be two things. Firstly, to avoid wrongful convictions or enhance fair convictions. Now, just like what Professor Vibhuti sir had asked a question, should convictions be the parameter of justice? Now it's a very cardinal question, and we should have our own answers, because just like sir has stated that so many things I have borrowed from your presentation, sir. I apologize for that. But yes, justice is a very slippery track. Like we cannot define justice absolutely. Can convictions be the replica of justice? That means convictions are taking place. Can we say justice is done? Now it's a very serious question. But yes, we are bound to change as per the society, and if the society's outcry says that conviction should be there, then as a stakeholder of criminal justice system, it is our duty that let the convictions be fair. At least we should avoid wrongful convictions. And that is why for wrongful convictions, we have certain terminologies called post-conviction DNA exonerations. I think in the morning, Professor Gurpur ma'am, she has talked about this, she has slightly touched this topic. So post-conviction DNA exoneration. There is research going on and Project Innocence kind of things are going on, in which after the conviction, DNA technology is used to find out the guilt of the person, because he has been formally convicted by the judiciary. He is now in the incarceration. He is facing the punishment. But does that mean he was really a culprit? And for that, DNA kind of advanced technologies are taking help. And with the help of that, they are proving that yes, these people were never involved in these kind of things. A very classic example of USA is Gary Dotson's case. In early 80s, this is the first case in USA in which DNA exoneration took place. A person was implicated in a case of a rape of one of his school friends, and he was given punishment of 25 to 50 years for one offense, and for kidnapping again 25 to 50 years. USA has this kind of fashion that sometimes they pronounce 250 years of punishment. This is not humanly possible to actually utilize. But yes, for that particular magnitude of offense, they prescribe this kind of punishment. So Gary Dotson's case, please read about that case. This is a very, very interesting case, and how DNA technology is now being used for exonerations. At the same time, conviction must be backed by forensic and circumstantial evidences. So this is where the debate starts. My upcoming case studies will be taking origin from this philosophy, how forensics as well as circumstantial evidences can lead to fair convictions, and how we can avoid wrongful convictions. Now, before we actually start with case studies, I will just give you a glimpse of what judiciary, have in perspective towards forensic science. Now, as both of our experts have already talked about judicial angle of forensics, Section 45 of Indian Evidence Act and Section 293 of Criminal Procedure Code. Both the sections are like doors of forensics to the criminal justice system. Under Section 45, forensic experts can be called to the court, and after coming to the court, they can give their testimony, they can give their witnesses, and upon that they can be cross-examined, because cross-examination is one of the part of rights of the accused and fair trial. So cross-examination will be there, and whatever opinion that they are giving, it is merely an advisory in nature. It is not a conclusive value, and judicial or a judge is not bound to accept that opinion. At the same time, Section 293 of CRPC, it is quite different. It's a scientific experts. There is a list, exhaustive list given in the CRPC. Of course, we are proud to say that NFS is one of those institutions. Now they can also give the testimony, and that testimony is directly admissible. But ultimately, these two are the facilitating doors in which forensic element can enter into the criminal justice system. So, when under Section 45 we are talking about expert testimony, how judiciary handles expert testimony? Because expert can be anything. If you go and check Section 45, the word forensic is not there. It's law, international law, art, these kind of things are used. Foreign law or art, these kind of things are there. So, when an expert comes to the court, you cannot expect that a judge is, having absolute knowledge of science or art or foreign law. It is not humanly possible, because a judge cannot be omniscient that he is having all the knowledge and databases. So maybe judge might not be able to ask scientific questions to a scientific expert. But does that mean that scientific expert will overpower the judge? No. Because ultimate authority is who? The judiciary. So what judge can do? A judge or a court can ask certain questions to that particular expert. Or what type of questions are there? So we have two types of tests. One test is Frey's test. It's a case in United States almost 100 years back in 1923. That systolic blood pressure kind of machine that was devised at that time. And that time that technology was quite new, and few lawyers took the help of that technology to prove that how guilt is there, how this person is guilty. But judge at that time asked the question that how can you justify, how can you substantiate that this technology is absolute, it is error free. And that is why the first question in Frey's test was posed by the judge is what? Whether the methodologies used in the expert witness follows the generally accepted practices of specialized in that field. Whatever technology that you are bringing to the court, whether that technology is widely accepted in your field or not, that must be told to the court or conveyed to the court. So here, judge might not be able to ask technical questions, but he can definitely ask a question: what is the sanctity of this technology? Are your colleagues believing on this? Whether this technology is widely accepted throughout the world? What are the modalities of that? So upon that answer, the next question would be asked is what is the credibility then? What are the modalities? That is how Frey's test was there. This test was used in many of the judgments. But later on, till Daubert kind of case came, that is Daubert versus Mareldow Pharmaceuticals in 1993. The new test came up, and that is called Daubert test. And let me tell you that Indian judiciary has also reciprocated towards this case, and they have used this test in many of the judgments. So what is Daubert test? The facts are quite interesting. There was a case in which what drugs was in question, whether that drug put some impact on the child in a womb or not. One female, one lady, she took that drug and she got some physical infirmities and some health issues. And she claimed that that particular drug impacted on her fetus or womb. So it was challenged. So her advocate gave certain evidences that whether this drug is really capable to put some influence. He gave that evidences. Counter evidence was given by the pharmaceutical company that research shows that there is no impact of drug on womb. So what is to be done? So counter questions came before the court, and the judiciary was in a position to handle this case. That what are those standards by which we can evaluate these kind of cases? So they came up with 4 criteria. Now those 4 criteria are called as Daubert test. What is the first criteria? The content of the testimony can be tested using scientific method. Whether this method is scientific or not. What are the parameters of that? How it is scientific? That is the first question. Secondly, the technique has been subjected to peer review, preferably in the form of publication in peer-reviewed literature. Now, publication is one of the aspects of science, because whatever scientific methods or theories are coming up, that needs to be published. And let the world challenge it. Somebody should challenge it, come up with their counterclaims, that is how science goes ahead. So whether this technique is amenable to the discussion, whether it was clearly tested, that is the second question. Third question, there are consistently and reliably applied professional standards and known or potential error rates for the techniques. How this technique is reliable, what are the potential errors, a judge must be acquainted with that. So after clearing all these things, then last parameter is once again Fry's test. How much it is generally accepted. So if a particular expert convinces to the judiciary that yes, these kind of things are fulfilled and the particular scientific method is that much capable, then that opinion can be accepted. But of course, as an advisory in nature and not absolute. So then, in cases, many times forensic evidence is involved, scientific evidence is involved, many times circumstantial evidence is also involved, but still we are getting acquittals. So per se we don't have any problem with acquittal. But as I said, acquittal gives several question marks, and it is our duty to find out why these questions are. So here, before I just move to the cases, here is one of the slides that I have picked up. We have already seen so many times that beyond reasonable doubt, this is the phrase that is used by Indian judiciary or throughout the world this phrase is used, that guilt must be proved beyond reasonable doubt. But there is a development that has come up, and in many of the judgments, ongoing judgments, now the new phraseology is coming up, that is beyond residual doubt. Residual doubt. Students of science law might be knowing that in laboratory when you go there is a residue, that is pipette, if you do certain chemical experiments, some residue is there. So this test says there should not be slightest doubt in the mind of judge regarding the guilt of the person. Beyond reasonable means fine, above average level if you go, a common prudent man is satisfied that yes, guilt must be there, that is fine. That is the beyond reasonable doubt. But residual doubt goes further and asks the judges, do you have any lingering doubts in your mind? Whether those doubts are satisfied. So that case is evolving several judgments. I have picked up few judgments like Ashok Dev Burma versus State of Tripura 2014 or Krishnan versus State, and there is a 1986 judgment of the United States Supreme Court. I will leave the PPT with you. You can go through these judgments and enrich your insights. So when we are talking about a residual doubt, the standard of evidence is so high, the degree of evidence is so much strict, and that is why many of the times even the Nithari case has come up on the touchstone of this, that guilt is not absolutely established. You have circumstantial evidences, you have forensic evidences, but they are not matching with each other. There are serious deformities and loopholes, and that is why so-called benefit of doubt is given to the accused person. Now when this benefit of doubt comes to the question, there are several question marks. What is to be done with that? And for that we need to have our scientific knowledge, forensic knowledge very much well equipped, because we are the law students, some of us might be getting in the judiciary, prosecution, investigation officers. So it is that high time that we must discuss these things, we must come up with certain solutions, at least possible outcomes from that. So these are the case studies. I will be directly dealing with two cases. The first case that I have picked is Rahul versus State of Delhi, 2022, November 2022. You must be knowing the name of this case as the Kiran Negi murder case of Delhi. If you have read it, then that's fine, but I'll just quickly make you acquainted with the facts. Kiran Negi murder case. As for the timeline, this particular case happened 11 months before Nirbhaya's case happened. In December, 16 December 2012, Nirbhaya case happened. On 15th of February, 9th of February 2012, Kiran Negi murder case happened. Almost 12 years before, 10 years before. Sorry, 11 months before. And Nirbhaya case has, now we have given death penalty to those people and the case is settled. This case was prolonged. So many, turns this case took, and ultimately it resulted into acquittal. Now, how this happened, it is very, very intriguing to understand why this happened. Let me tell you the facts. There was a girl who was returning from her job along with her few female friends and one male friend. She was going towards her home. It was the night time. Suddenly, a red colored Tata Indica car approached, and a few people were inside. They just grabbed her inside. Her friends tried their best to retaliate. Nothing happened. They just kidnapped her. They left the place. And after that, one of her friends, she lodged an FIR. She made a phone call. The police came. They visited the crime scene, and then they started investigation. First source that they got is red color Indica and kidnapping, nothing else. So on wireless, they started inquiring so many things. After 2-3 days, they found one red colored Indica roaming here and there that was matching with the description. So they arrested that particular person. Investigation went on. That person gave the confession, yes, we gang raped that girl and we murdered her. Then upon inquiry, where is the body? He showed that yes, under section 27, it could be a relevant statement that he was ready to show the body. So he took them to the a field, remote kind of field near Haryana. And the body was naked and it was lying there. For 3 days, the body was lying there. So body was recovered. Then few a cell phone and broken pieces were also found at that place. Some of the circumstantial evidence like wallet and so many things were found at that time. So police formally started with the investigation. The photography was made and seizure memo was also did. So many things. Whatever written procedure that policemen wanted to do, they did. And the case went on. The evidences were produced. The evidences recognized the perpetrators. The session court gave the death penalty to all the 3 accused because 3 accused were there. Their names were Rahul, Ravi, and Vinod. Now these 3 accused persons were given death penalty. After a few years, the High Court also affirmed that yes, death penalty is an appropriate case because the case very well falls under the arrest of their category. And then the case reached to the Supreme Court. And Supreme Court has appointed Sonia Mathur as her amicus curiae in the court. And formally the case reached to the Supreme Court. And once again, Supreme Court wanted to evaluate the evidences and arguments went on. In that case, the real thing came up before the judiciary. How the investigation happened, what are the loopholes that they did. This case will show you that. Firstly, grounds of the acquittal. Let's do reverse engineering. Let's first find out why acquittal was there. Firstly, identity of the accused was not duly established by the witnesses. So accused people were not recognized by the witnesses. Secondly, circumstances under which accused were arrested and the car was seized have raised so many doubts because policemen were not efficient to handle these kind of things. They did not seize the car. So many things were left like that. So that also impacted, that resulted into benefit of doubt. Thirdly, number of inconsistencies and contradictions appearing in the evidence of Haryana police, Delhi police. A typical kind of jurisdictional matter was there that this falls under your jurisdiction, this falls under our jurisdiction. Then one more anomaly was that the police were having confusion that who reached first to that crime scene because one police party reached there, already somebody was there. So they were having that contradiction who came first, and that raised a doubt. If somebody has already reached, what precautions they did to secure the crime scene. Possibly the policemen reached first. They were the first contaminants of the crime scene. That was the question raised by the defendant. So that also resulted into benefit of doubt. Then it is highly unlikely that the dead body would have remained in the field for 3 days without even notice. That was again a question mark. That also resulted into acquittal. The samples of the accused and deceased were kept in police station Malkhana for 11 days. That was again questionable. And inconclusive post-mortem report, the cause and death, time of the death was not substantially, established by the CFSL. So these are some of the grounds of the acquittal. Now, observation by the trial court. Trial court was quite happy with the investigation and they said fine, everything was properly corroborated and even DNA report is there. So when DNA report is there, it's a gold standard report, gold standard evidence. So that is why there was no harm. So I'll just take you to that fact how DNA evidence was established before the court. And these are the observations by the Supreme Court that again Supreme Court has raised several question marks that even the cross-examination was not conducted by the Sessions Court. Then the test identification parade was not conducted. So many things are there. When it comes to DNA samples, now in this case, just understand the facts. The body was found after 3 days in the field. Whatever hairs on that body, one of the hair strand on that body belongs to the accused person because she was having a hair strand on her body. So scientific team they collected that hair strand. It was sent to the FSL. Samples of hair strand of the accused person they were also taken. One of the accused Vinod and Rahul, their hair strands were matched with the hair strand that is found on the dead body of the women. Then in car back seat, they found a hair strand that belongs to the female victim. Then on the same seat, there were some semen samples, some semen stains were found that were also established with the semen of one of the accused, that is Rahul. That means DNA samples were quite matching. And trial court and high court was very satisfied that yes, if the DNA samples are there, they are matching. What else you want then? The guilt is quite beyond reasonable doubt established. But the Supreme Court, the amicus curiae and the Supreme Court both remark on this point that when a body is lying down for 3 days in a maize field and without even noticing how that hair strand remain on that body, is it not possible that you forcefully took the hair strands of the accused person and kept it on the body? Is it not impossible? Or you have taken the hair strands of the female victim and kept it in the car because for 3 days your car was not seized. These are the doubts raised by the Supreme Court. Then whatever the semen sample they have found in the car, that does not mean the gang rape had happened because that does not conclusively implicate the accused person. A semen sample, presence of semen sample does not directly say that the rape had happened there. Again, that question mark was there. So these kind of loopholes ultimately resulted into benefit of doubt. Now these are some of the lessons from that case. Firstly, the DNA samples collected must be sealed. Had they had the proper sampling mechanism or packaging mechanism, they would have already sent it to the CFSL. But for 11 days, if you take the biological sample and keep it in the police station Malkhana, where we all know that what or anything can happen with the samples, what is the sanctity of that samples? What is the credibility of that evidence? So here there is a serious lapse on the part of police or investigation officer. Secondly, collection of the samples of the blood. They were again doubtful. They have come up with the theory that yes, there are some spanner and panas that are there, toolbox of the car that was blood stain. But again, that was not conclusively proved. Thirdly, since it was the case that who reached there first, the crime scene management was very, very poor. That again raised certain doubts. Then witnesses were not cross-examined. That is one of the precious rights available to the accused. In the absence of that, you cannot call that is a fair trial. If the accused doesn't get the right to cross-examination, that creates suspicion on the prosecution. So that was there. Case identification parade was also not conducted. Then along with DNA samples, the way in which they were picked, that was the first allegation by the defendant, how it was picked. Because at that time, the policemen were not having adequate kits, adequate means to collect the samples. So that, and there was no record on the case that how it was collected. So that again gives rise to several doubts. Then step by step, if you go to the case, you will find these are the loopholes. Kidnapping was not established. Arrest was not properly done. Not shown on the paper because there are several violations of dozens of provisions of CRPC. The recovery of the body, that also created so many suspicions and doubts. Daily diary records were not produced before the court because we know that if an FIR is lodged, the general diary number is there and on general diary the FIR number is there. But when they actually recorded the seizure memo and photography that they did, photography and seizure memo must match with each other. There were certain things that are in the seizure memo but not seen in the photographs. That creates one more suspicion. What kind of seizure memo is this? So that was again doubtful. Then delayed submission of sample to the CFSL, that is one of the important loopholes. And because of all these things, the case resulted into acquittal. Now this case gives us certain insights. No matter you have a DNA samples, DNA evidence, and to process that DNA evidences, you have most advanced labs, like crores of rupees have been spent, ultra modern equipments are there, so many things are there. But when it comes to processing of the forensic evidences, what type of assurance do we give to that? How the work of forensic starts? You give me an answer. If I ask you a question, where the work of forensic science starts? When the samples reach to the laboratory or when the samples are actually collected? What is your answer? Can somebody answer me?
When the samples collected.
When the samples collected from the crime scene. That is correct. Because unless that samples are collected properly and with a greater precaution, they cannot reach to the lab. And even if you have a most advanced labs, if they have inferior quality or contaminated samples, the outcome would be always doubtful. The benefit of doubt is bound to happen. So that gives us a very important insight that the person who is actually picking the samples, he must be educated. He must be knowing what is forensic science. He must be knowing what type of evidence he is handling. That kind of training is required to that person. That kind of capacity building is required for that person, which is seriously lacking in India. When we are talking about police database of USA, we are at very nascent phase. Let's just admit that we have to go many miles further. We must start with the constable level because what Professor Vibhuti sir has already stated that in Criminal Procedure Identification Act 2022, that authority is given to the head constable level Section 3 of that act talks about measurements. You can collect bodily samples, behavioral attributes, gait pattern, how the person walks, everything can be recorded and can be kept for 75 years. And who is that person who records or picks the sample? The constable. There was a huge debate. Can this kind of rights to be given to the constables? There was a huge debate on this point. Is it feasible? What is your answer? What do you think? Should it be given to the constables? What is your answer? There could be two answers, yes and no. The person who will say yes, because they are the one who actually respond to the crime scene. You cannot expect that SP will come or IG will come to the crime scene. The first person is reaching to the crime scene is who? Patrolling party or a constable. So capacity building at that grassroots level is very, very important. Then whosoever are saying that they cannot be given these kind of authorities, then to whom these authorities should be given? So because of this, on 18th of September, because on 4th of August, CRPI Act came, and on 18th of September 2022, they come up with criminal procedure identification rules. In that rules, they just diluted that provision, and along with head constables, now medical practitioners, they were also given the power to collect the samples. Now again, medical practitioners must be duly registered. Their qualification is important, but they are capable. They are given legal authority that they can definitely collect the samples. So when these samples are collected, they needs to be processed. They needs to be packaged. Not all the samples can be packaged in a metal box. Not all the samples can be packed in a plastic box. Not all the samples can be packed in a paper box. There is a segregation of samples because DNA forensics or biological samples could be variety of nature, and one size fits all formula is not there. That is why this kind of training is very, very important. We at NFSU are regularly imparting this kind of training, hands-on training to these people. We are having, as my dean, Professor Pokhriyal ma'am has stated, that we have mobile forensic vans in which almost all the machineries that we have in forensic labs, they are mounting on that mini truck, mini car, that kind of van. That van can travel, and that van can be actually taken to the crime scene, and from there and then you can release the forensic report. That kind of facility is now given by the NFSU. Now coming back to our next case, that is Nithari judgment. Now I just presume that you all know the facts of Nithari case. Like it is very unlikely that you are not knowing that fact. If you don't have by any chance knowing this fact, please go through it because your knowledge of criminal law would be incomplete if you don't know this case. Okay. And in fact, yes, Allahabad High Court has given 308 pages judgment. And almost every page is enriched with so many insights and so many guidance. Of course, judgment is about acquittal, but there can be so many understandings from that. I'll just take you to the before we actually start with the Nithari case analysis, I'll just take you to these four elements. When it comes to forensic evidence, these four types of impediments, or you can say barriers, that are going to be faced. Firstly, it comes self-incrimination. That is under Article 20, Clause 3 of the Constitution of India. The text of Article 20 says, no one shall be compelled to be a witness against himself. To be a witness against himself. Now, this is the phraseology that has been widely interpreted by Supreme Court. One of the finest example, the case that Sir has already stated, that is Selvi's case, Selvi versus State of Karnataka, 2007. Now, in Selvi's case, they have cited one more landmark judgment, that is Kathi Kalu Ohad versus State of Maharashtra, 1961. Now, this Kathi Kalu Ohad's case has already deliberated upon this aspect, that what do you call as a self-incrimination? To be a witness against himself means what? Now, in 1962, DNA forensics was not there in India at least, and we were not having most ultra-modern facilities like voice recording or behavioral attributes or so many technologies, BIOS or narcotics. That was not there. But Constitution of India was there, definitely in 1962, and Article 20 Clause 3 was definitely there. So that protection was there. So when you are taking blood samples or fingerprints or voice or semen sample or hair strand or nail clipping, anything from the convicted person, does that violate his constitutional protection? Can we say that you are violating his right against self-incrimination because you are taking a part of his body from him without his consent maybe, or he is opposing, I am not allowing you this, still you are taking and processing it. Does it not violating his right against self-incrimination? So in Kathi Kalu Ohad's case, Supreme Court has decided that what do you mean by to be a witness against himself? The Supreme Court cross-sectioned the word witness. What do you mean by witness? what witness does. A witness is a person who actually comes to the court, he stands in the witness box, and he gives his testimony. How he gives the testimony? By uttering certain words. That is the meaning of witness. So no one shall be compelled to be a witness against himself. Nobody shall be compelled to come to court, stand in the witness box and say something against himself. That is what the protection is. That was the quite narrow-minded definition at that time, but that definition is still, followed by the Indian judiciary. That when you say to be a witness against himself means calling that person and asking him to speak against himself. Taking fingerprints, taking DNA sample, taking blood samples, hair strands, nail clipping, voice, semen, anything does not amount to be a witness against himself, because prima facie he is not saying anything against himself. He is not speaking anything against himself. He is just giving certain bodily sample. Prima facie that does not amount to self-incrimination. The same ideology was borrowed in Selby's case. They have numerous times, followed the judgment of Kati Kaluga. So that is how we are dealing with the cases of self-incrimination. So Indian judiciary is trying to, facilitate the criminal investigation in their way, because if you follow strictly this particular thing, no criminal investigation can go further. That is why there has to have a rationality, how we can cope up with the rights of the accused, at the same time the justice to be done. So these kind of things are there. And secondly, privacy, consent. Again, Selby's case is important. Consent is absolutely required, because when you have methods like narco analysis, which are invasive in nature, you are injecting that person some foreign element and he is speaking certain things, he must be given the consent. Without consent, you cannot carry out this kind of techniques. What if the consent is manipulated? Then there are cases in which two tests were going to be carried out: polygraph and narco analysis. The investigation officer was quite wise. He took the consent of the accused person for polygraph, lie detector. It was properly explained to him what is lie detector. Everything was explained. He gave the consent. Same consent they used for narco analysis, and then accused person challenged it. I only gave my consent for lie detector, which is non-invasive technique. When it comes to narco analysis, it's an invasive technique. You cannot import the consent for polygraph or the consent of narco analysis. You have to take the separate consent. And again, benefit of doubt was given to him. So that much relevancy or that much paramountcy we are giving to the consent. Privacy is a very important right of the accused person. Then accuracy. Even after you are conducting so many forensic methods, what is the accuracy of that? Many times we use the word the DNA samples were matched. There is a 90% match, there is 80% match. Does it really work on the percentage? Is there kind of percentage criteria over there? Let me tell you, DNA science is entirely based on the probability. It's a probability sample. How much is the higher probability of matching of these two types of DNAs? There is not kind of 90%, 80% actual criteria, but probability. And the probability is of so much that you cannot override it. Because if you take the samples, sometimes the probability is so sure that this sample would be of this person. The probability is 1 in 7 billions. Now the actual population of the earth is 6 billion. So that much higher level of probability is there, and that is why we are saying it is actually the conclusive match. So you can see several videos on that, how STR, short tandem repeats, and that technology is used. In fact, legal fraternity should not be deprived of this scientific knowledge. That will definitely add on to your perspectives about criminal law. So do visit several videos, or make some research on what is STR technique, short tandem repeats. Then after accuracy, the next part is admissibility. How much evidence is admissible in the court of law? Just because it's a forensic evidence, are we going to admit? So these are kind of issues. First two issues are somewhat dealt in Selby's case, and other two issues are dependent on quality of samples and timely submission to the forensic labs. Okay. If you want accuracy, if you want absolute admissibility, let the samples reach to the forensic science lab in actual time, real time. More the time period is there, more the results will be vague and contaminated or inferior quality. Now in Nithari's case, like what Allahabad High Court has analyzed is conducting of narco analysis, because in this case there were 4 techniques that were relied by the prosecution. Firstly, polygraph; secondly, BIOS; thirdly, narco analysis, and several other techniques of forensic science. Amongst that, I have picked the analysis for narco analysis test. Whatever I have portrayed over here, these are the words of Allahabad High Court. Firstly, conducting of the narco analysis test. Now we all know the person is subjected to the narco analysis. First thing that prosecution must do is what? Obtain the consent. that is informed consent, not just consent yes or no. He must be known what kind of technique is it. He is bound to say no, or he can say no at any time, but still he is giving consent. That consent is very, very important. Conducting of narco analysis is the job of whom? The forensic expert. At the same time, obtaining the consent is the job of whom? Investigation officer and prosecutor. They both must take care of these things. As per this case, in Nithari's case, Surendra Kohli, he was taken to the Gandhinagar and his narco analysis test was carried out in DFSL. And that was conducted by a very renowned scientist and very renowned expert. Her competency or the officer who took this narco analysis, beyond reasonable doubt, she has conducted more than 4,000 polygraphs. So her capability and experience was not inferior to anyone. She is quite capable. So no question mark by Allahabad High Court on her competency of carrying out the technique. Everything was fine. About investigation, if you want to conduct narco analysis, you have to take the consent. These are the things that they did in the Surendra Kohli's case. Firstly, non-production of accused before magistrate for getting consent. Prosecution was saying we have taken consent. Where? When person was actually in Tihar. He was in Noida in the police custody. There they have taken his consent. Now, as per the defendant lawyer in the Allahabad High Court, how can this be a free consent? He was never taken to the magistrate. There is no impartiality. It's just like a confession before the police under section 25, which is not admissible. So this consent is quite vague, and that is not fulfilling the right against the self-incrimination. That is why non-production of when that person was not taken to the magistrate, then that means you are not given him chance to say no. He was bound to say yes. That anomaly was there. Secondly, accused to remain silent, remain in police custody continuously, no access to the lawyer. Now, police custody is the word that has been interpreted by the Supreme Court in so many cases. What do you mean by police custody? This word is also there in section 26 and 27. These are the two sections of Indian Evidence Act in which police custody is the word that is used. What do you mean by police custody? Now, police custody means actual custody, physical custody, as well as indirect custody or surveillance. Even if the policeman is not standing with you, not accompanied to you, still you are under surveillance, you are not having any liberty to go anywhere, that means you are in police custody. Of course, there is one more judgment of Madhya Pradesh High Court has come in a few days back, Rajesh versus State of MP, in which one more ideology has come that police custody means when a formal FIR is lodged against you, then and then only it can be called as a police custody. But in Nithari's judgment, they have not cited Rajesh judgment as such. They have taken yes, police custody means you are under constant observation. Even if that person was taken to the Gandhinagar for narco analysis, even if the policeman was not standing there, he was in the custody of scientific expert, still he was not having liberty to go from there. He was bound to be there. That means control of police was already there. So under those circumstances, it's a forceful thing, the consent is actually manipulated, plus you have not given him any support of lawyer, no legal aid. These are the violations of fair trial. Understand, you are dealing with forensic evidence, at the same time you are violating fundamental tenets of criminal law, fundamental principles of criminal investigation. No access to the lawyer means you are violating his constitutional rights. So that was also taken care by Allahabad High Court while acquitting the person. Third, allegation of tutored sentences and force of memorization of facts. Now this is very, very interesting. Understand what type of method of narco analysis is. Narco analysis means some injection is given to you, some chemical is penetrating your body, you are under that influence and you start speaking. Okay, you just start speaking, certain questions are asked to you and you speak, and that is recorded, question answer format. Now, accused person can anytime say that whatever I have said, I did not mean it. But since he has already given the consent, whatever is recorded, that is on the record. Here, as per the prosecution, he has narrated entire incidents as it is. How those kids and women were lured by them, how they were invited in the house number D5 of that Jal Vihar of Noida and that Nithari village, how they were manipulated, how they were sexually abused, how they were killed, how their body parts were chopped, how that was cooked and how it was eaten and how the body parts were thrown. Everything was narrated by the Surendra Kohli. That was on record. Now, when it comes to consent issue, when he was asked the question under section 313 of CRPC, the magistrate has asked him questions, he took the plea that prosecution has forced me to narrate these facts. They took the rehearsal from me. They pressurized me to memorize the facts. And that is why several times I spoke the same facts. And that is why when narco analysis was happened, I spoke the same thing because I was given the practice by them. So whatever I stated, that was because of that memorization. That stigma was there on my mind. And this was taken by the Allahabad High Court as one of the turning points of the cases. When you have already memorizing of facts to the accused person, possibly he will say whatever you have already forced him. That is why an entire incident was the narrative set forth by the prosecution. And that allegation could not erase by the prosecution, and that is why benefit of doubt was given. Last thing, testimonial compulsion. When you are under police custody, you are not having any access to the lawyer, you are subjected to so many forces or tortures, tutoredness, everything, then you are doing testimonial compulsion. And when it comes to testimonial compulsion, that is violation of Article 20 or 3. That is why, in this case, narco analysis was involved. On paper, everything was there. Still, it was rightfully rejected by Sessions Court as well as High Court. Both the courts have rejected. In both the cases, in Sessions Court and in High Court, they did not rely on narco analysis test. Okay. Now, there comes two things. Whether there was a coordination between forensic experts and IOs and prosecution. Was it there? There are severe lacunas in that. The forensic expert did not know at what time they reached to Gandhinagar, where that they were staying, under whose custody it was. After the test, where they are taking to this particular accused, no information was available. At the same time, IO did not explain anything to the forensic experts. So this lack of coordination actually violating so many rights. What are those rights? That are given under NHRC guidelines. NHRC has prepared certain guidelines on polygraph and narco analysis. That were taken to the court. While narrating certain contentions, the defendant has taken the help of these guidelines. And these guidelines were not followed by either investigation on the part of forensics. So there is this kind of lapses are there. And that ultimately frustrates your gold standard of DNA evidence. And this is where our attention should be there. In fact, entire legal fraternity should focus on this part. How we can bridge the gap between forensic science and criminal investigation. In fact, they should be complementary and supplementary with each other. But at this moment, they are poles apart. The forensic fraternity does not know about criminal investigation. The criminal investigation does not know the sanctity of forensic evidence. If these kind of things are there, definitely acquittals and wrongful convictions are inevitable. And these are the insights obtaining the consent of the accused by producing before the magistrate. Had it done before, at least one question mark we would have raised. What it takes to, how much expenditure do you take that person to be taken to the magistrate? A simple thing that you could have done, but they did not do it. Secondly, providing legal aid and access to lawyer. Are these like very expensive things? Are these like very negligent things? You should have already done it, because ultimately these points become very, very severe at the time of acquittal. Thirdly, establishing firm evidence about absence of torture and force. These allegations were not at all erased by the prosecution. Then next, torture, tutor and pressure. Three things were there. No answer from the prosecution on this point. Strict compliance with the NHRC and other SOPs. As sir has rightfully quoted that there is no standard SOP for pan-India investigation. We are still in the process to make SOPs, but there are few SOPs that are there in jail manuals or some of the independent organizations like Delhi Police or many of the police institutions. They have come up, PPRD also come up with certain guidelines, SOPs, but they are not having the statutory force like CRPC. In fact, these guidelines must be the part of one of the annexures of CRPC or at least evidence, any appropriate law, or to that matter, Criminal Procedure Identification Act. Somewhere down the line, those SOPs must take the legal statute, shape of the legal statute. At present, we have not worked on that. That is very important. Then efficient coordination between agencies, forensics and investigation, as I have already discussed. Now, what are the attributes of robust forensic investigation and what is to be done? What is the way forward for us? Firstly, collection of samples from the crime scene. A due attention must be given to these kind of people, SOCO officers of Karnataka, or any person. In the language of forensics, we call them as the first responders. Those are the people who actually reach to the crime scene. They must be very well aware about how to secure the crime scene, how we should prevent unauthorized entries, because any type of contamination will directly result into benefit of it. That much severity you should be knowing. The investigation officers must be, educated, made aware that your slightest mistakes are going to frustrate entire hypothesis of prosecution. That is why they must be very, very diligent, very, very transparent. I happen to have a participation in Central Academy of Police Training, CAPT Bhopal, in which they invited IOs, forensic experts, prosecution and judicial magistrates. And in that deliberation, one of the prominent suggestion given was that these people should have, helmet and kind of camera mounted on that, so that wherever they go, everything will be recorded. Because in this case of Kiran Negi, that is Rahul's case, it was an anomaly that who reached first. In the absence of that proof, we did not know who reached first and who collected the samples. Had they had that kind of cameras on their helmet or kind of thing, or shoulder mounted cameras, they would have captured entire procedure. That would be having evidentiary value, electronic evidence is there. So these kind of things must be taken care of, and I think when the public opinion will come in this way, definitely the legislature is bound to listen to the public opinion. We have seen several times, because most of the crucial criminal amendments had the backing force of public opinion. So when we are, making rallies and making, public opinion channelized for the rights of the accused, I think one rally should be there for strengthening of police force. One rally should be there for strengthening the prosecution, because ultimately these are the people who are standing in the court. They are defending your rights. If they are not educated, you cannot expect fair procedure. You cannot expect justice for the victims. And that is why collection of samples is very, very important. Secondly, storage of the samples. What type of material is required? Everything must be there. Let me tell you that our Delhi campus of NFSU, they have prepared a database and a book in which variety of evidences and how to package them, that is there. The book is about to get launched in further days, like that will be available. So in that case, it is very important to teach them, the responders, that how to collect that sample and how to process it. Thirdly, that samples must reach to the FSLs in timely manner, not like they are keeping them in the police malkhana, having contributed how to pack it, where to send it. All this kind of contact list must be available. The first responders must know that what is the next stage. One of the prominent factor that is resulted into acquittal is lack of chain of custody. Have you heard this word, chain of custody? Chain of custody means a paper or a sheet in which every person and his detail is recorded, whosoever handles the samples of the evidence. That means first responder who has collected the samples, he will narrate his name, time, signature. The next person who will touch that sample, he will also narrate his name, dates, everything. By this uninterrupted chain of custody must be there. If that uninterrupted chain of custody is established in the court, that will enhance the probative value of the evidence. In many of the cases, the chain of custody is interrupted. There were several lapses, and in the absence of unbreakable chain of custody, there is a suspicion. Then who has handled that particular sample in that gap? Was there unauthorized access? What was manipulation? Where there was some contradiction? There could be so many things. So chain of custody is very, very important, and for that, police force must be educated. In fact, IOs and prosecution must be educated for that. Thirdly, rendering expert opinion in the court, forensic. Just the way investigation officers must know about forensics, the forensic teams must also know about legal procedures. They must know that whatever evidence that they are going to render, what impact it will put on the case. They should be very, very conscious about handling this particular thing. In many of the cases, we have witnessed in NFSU as well. Many times, the investigation officers are not aware about keeping the sanctity of the biological sample. Sometimes the entire charger, entire blanket comes to us, and then it was like you find out the semen samples and blood samples that are lying on that. And then it's a task, like many times that sample, the bed sheet or that particular blanket, that is washed. So once it is washed, the evidences might go away. But now there are techniques in which even if you wash that fabric for 4 to 5 times, still you can extract DNA. That much science is making progress. But when we have this kind of progress, let's not forget that the crime and criminality is also changing. Now there are many cases in which the perpetrators of rape, or those people who are criminals who are committing rape, they are forcing the victims to take shower after the rape. They are forcing them to wash away all the bodily fluids. Now that kind of things are also there. So when or unless they are taking away their clothes and burning it right there to diminish or eliminate all type of evidence. So these kind of things are also happening. So when criminality is changing in this way, it becomes a very tedious and very atlas task for us to understand that what is to be done with that and how we should come up with fair procedures. So at the same time, we want to protect the rights of the accused. At the same time, we have to go toward the justice. So that thing. And then lastly, forensic evidence assisting to the precise conviction. More the samples are corrected, more the procedures are firm and transparent, then more the accurate the forensic findings will be there. And then we can say there is a fair kind of conviction happening. So for that, concerted efforts of all the stakeholders are very, very important. Everybody should know what next channel is going to do or what next person is going to do. Investigation, prosecution, judiciary and forensics, they must have united, collaborative teaching a kind of sessions in which everybody must know that what next person is going to do. Judge must know the technicalities of prosecution. Prosecution must know what is forensics is doing. Forensic must also know what the investigation is going to. Everything should be shared. This kind of joint learning platforms must be prepared. Then, at the same time, investigation officers, their training, there could be so many things that we can discuss. So at the end, I would say that so by comparing all these cases, I would not say that we'll be very, very pessimistic. We have cases in which we have appreciated forensic evidence. One of the classic cases that I wanted to quote here is, and those who are interested, you can read that case, Gaurav Jadhav versus State of UP 2014. Now in this case, the cause of action, Gaurav Jadhav versus State of UP 2014 Supreme Court. In this case, there was a lady, in 1992 the cause of action happened. A lady came from New Zealand. She stayed in some of the cities of India as a traveler. She went to the Varanasi and after that she became disappeared. She used to make phone call to her father in New Zealand. After a few days her phone call stopped. Her father was worried, she was not found. Her father contacted the embassy. The embassy did not have any answer. He came to India. He started doing local investigation. He also filed an FIR. The policemen started searching everything. Somebody told that your daughter went to Varanasi. So he reached to the Varanasi. He made several searches. The daughter was not found. Then he met the IOs over there and somehow they started investigation. So it was found that her daughter, his daughter was with her guide. One guide was there, tourist guide, and they both were seen on a railway station. After that, nobody saw that girl alive. That was the thing. So that guide was, investigation started to find out those guides, and that guide was found in a railway station. He was taken into custody. He made a confession that yes, this particular murder was made by me. The skeleton was recovered, DNA samples were taken, and then investigation went on. Here, the investigation officer relied on three things. Firstly, last seen theory. You all know what is last seen theory, that you have to establish, the offender has to establish, he was away from the victim when she was last seen alive. If he could not prove, that means victim was murdered by him. Secondly, DNA samples. Those DNA samples of the skeleton matched with the DNA samples of the father. And then, to ensure that really she was the victim, her skull was procured. Some of the photographs of real photographs, their negatives were developed. Their negatives were posed on the actual photograph of the skull. It was superimposed, angles were set, and it was matched. And that is how the conviction was given. So it is one of the cases in which traditional evidences as well as forensic evidences both were appreciated by the judiciary. It was really resulted into conviction. But in the absence of this kind of procedure, all we have is some kind of acquittals, and this is very, very it's a blot on our system that we cannot make those robust investigations. So at the end, the last slide has gone, but I will quote that no matter, yes, forensic evidence is of a gold standard, but to preserve this gold, we will need an iron kind of solid locker of circumstantial evidences. In the absence of that, robbery is inevitable. Thank you so much.